order. Welcome to the July 12th, 2021 meeting of the City of Raleigh Board of Adjustment. My name is Rodney Swink and I'm chair of the board. I'd like our board members to introduce themselves, starting to my right with Mr. Kinney.
Steve Kinney.
Kathy Rudisil.
John Kuntz.
Justin Sutton.
Marvin Butler.
Thank you. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. We are authorized to hear requests for variances from the city's UDO, special use permits, appeals from final determinations made by city officials charged with enforcement of the city's Unified Development Ordinance, and other requests as may be provided in the city's ordinances. In hearing cases, the board conducts a quasi-judicial evidentiary hearing. That means it's like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from some other types of land use decisions, like rezoning cases, which are legislative in nature. This board's decisions are constrained by the standards in the city's ordinance and the facts presented at the hearing. The board hears and considers evidence presented at the hearing and applies the standards set forth in state law and the city's ordinance. The board must base its decisions upon competent, material, and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. This meeting is open to the public and everyone is welcome to watch. However, participation is limited. Parties have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Witnesses may testify as to facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. For variance requests, a 4/5 vote of the board is required to grant the variance. For all other hearings and matters, the decision will be made by a simple majority of the board. To let us know what's happening, one of our members is absent, so Mr. Butler will be having voting privileges today. So we'll now conduct the evidentiary hearings on today's agenda, beginning with old business. BOA 0010-2021, 11009 Ingleside Place. Is Mr. Birch or Mr. Mills available? Will you please come forward? I understand you have a request.
Yes, sir. Good afternoon, Chairman Swink, members of the board. We would like to request that this case be deferred for another month as we continue conversations with the City Attorney's Office on how best to resolve our issues at this site.
Okay, that would be to the August 9th meeting.
Yes, sir.
Okay, we have a request to defer to the August 9th meeting. So moved. Thank you. Now we'll move to new business. This case is evidentiary hearing BOA 0050-2020, 8644 Kings Arm Way. And this is a variance. Mr. McDonald, let me swear you in, please. Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed with your presentation.
All right. Thank you. Give me one moment. So before I read the nature of request, I just did want to make one minor correction. For the record, the original legal advertisement for this case listed the address as 8644 King Arms Way. The correct address should be 8644 Kings Arms Way. That's King with an S. So just wanted to make that correction. It should be updated in board docs and in the presentation materials for you all. So with that being said, I'll go ahead and read the request in this instance. So whereas Michael Lyle, trustee, MLL Trust, and Kimtan Dole, trustee, KT Dole Trust, property owners request a variance to sections 923A2A1 and 923B1B of the Unified Development Ordinance, which requires fences to be located outside any primary watercourse buffer in order to construct a fence within a portion of the required 60-foot primary watercourse buffer in conjunction with a detached house on a 9.7 acre property zoned R1 and Falls Watershed Protection Overlay District located at 8644 Kings Arms Way. So here is the subject property. It is within the R1 district, so it's a fairly large lot, close to 10 acres. And the portion of the property that's under consideration today really is the southern piece near the adjacent cul-de-sac, which is the terminus of Kings Arms Way. So I'll proceed to the plan document for your benefit. So the request is specifically related to a primary watercourse buffer that intersects the southeast portion of the property. You can see in the bottom right portion of the screen here. So the code requires a 60-foot buffer along all primary watercourses. The purpose of that buffer is to diffuse the flow of stormwater so that it does not become confined and channeled, and so that the natural infiltration of pollutants can take place. Along with that buffer, there are certain allowed uses and prohibited uses. One of the prohibited uses is fencing located within the buffer itself. So the inset image shown here details the extent of the fence that will be located within the primary watercourse buffer. And the image in the top left, that kind of picture, shows what the proposed fence will more or less look like as it extends through that buffer. This plan just provides a little bit zoomed in image, again showing the extent of the fence, which is really intended to guard along Talo Court, where there's concerns related to both privacy and safety, such that the property owner and adjacent residents have witnessed persons and children playing and or getting close to that specific boundary line. And so they believe the fence will both help to secure the property and prevent anyone from accessing or for whatever reason getting into that buffer and the stream below, which there is a significant drop off at that point. And so that is the general purpose and intent of the request. There's also provided landscaping that's proposed, and so there's a landscaping key and table shown for you that's intended to more or less replicate the conditions that exist along the watercourse buffer. I believe the applicant can provide more information on that detail if you'd like. And that being said, staff really does not have any comment on the variance standards for this case. I will note we do have representation from Stormwater here if there are any specific questions about the requirements that are being referenced. And I know the applicant, is ready to present as well. So I'll take any questions at this time, and if not, I can pass it off.
Okay, thank you. Do you have any questions from the board? No? Okay, then we can now, the applicant is able to present evidence and legal arguments in support of the request. And again, as a reminder, any evidence and argument must focus on the applicable standards. So will the applicant please come forward? Before you begin, please state your record for the name, your address, and your relation to the case, and I will administer the oath.
Good morning, Chairman. My name is John Sparati. I'm with Smith Debenham here in Raleigh. Our address is 4601 Six Forks Road, Suite 400, Raleigh, NC 27609. With me is my law partner, Lauren Reeves. We represent the trustees that hold title to the property. As you probably saw in the application, we're seeking the variance primarily from the hardship.
Just one moment. Let me give you the oath, please, first.
Okay.
Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
You don't need to swear that if they're representing the applicant, they don't need to be sworn in.
I just realized that we changed that. Thank you for the reminder. I apologize, sir. You may go ahead with your presentation.
Thank you. And as we said,
Pull the microphone down just a little bit. Thank you.
As we said, this was for 8644 Kings Arms Way. We're seeking a variance from the stormwater buffer requirements just simply because of the hardship that it's going to impose on my clients, the landowners. In this case, the piece of property that is the subject of the discussion is contained within inside of a larger neighborhood, but is not subject to the same HOA requirements as the HOA, the surrounding neighborhood. The surrounding neighborhood's beautiful homes, well-maintained lawns, they're fairly strict. And this particular piece of property, which can, as you saw from the thing, cannot be seen from the primary residence that's their home. It is sort of out on its own. It appears to be, for lack of a better word, undeveloped. It does have an attractive nuisance on the piece of property, which is a stream. There is a lot of children in the neighborhood. We'll show some pictures. As far as in the neighborhoods, our clients, as previously mentioned, have had issues with trespassers coming down there, evidence of small parties, beer cans, chip bags, cigarette butts. It's a nice little private area away from the neighborhood, but it is a safety concern because, as we'll show you in our presentation, is as soon as you come off the maintained common area, which is actually in the picture there, there is a set of hedges, and once you step through the hedges is a 10 to 12 foot drop off that leads directly into what is an ephemeral stream. Our pictures will show running water, but that was thanks to our tropical storm passing through. We do have a set of exhibits. I have the old-fashioned PowerPoint, which is printed documents, if I can hand them out to you. And then we'll also have 3 witnesses that'll present some very brief testimony. It's going to include our homeowner, our contractor, and then also our engineer that helped develop these plans, or not helped develop, drew them out for us, and also participated in obtaining the required permissions from the DOT, environmental quality, and different agencies that were impacted by the extension of the pipe that we'll show you. If you'll give us just a minute to pass these out.
Yeah, let's start with Ralph, and then you can go around, so you have a copy.
And you're asking that these be submitted to the official
I was
record.
going to say, I'd ask that be submitted into the record once we have a excuse me, a chance to go through them, diagrams which you have seen before. And I also would probably like to go ahead and swear in our first witness. It's going to be KT Dello. She is the trustee. You ready?
Please state your name.
We're using this one, but I'm not,
Is whatever's easier for y'all.
I didn't even know there
If
was
you don't
one over
mind,
there. I would use this one just for consistency purposes.
this is our
and we
first
can-
meeting back in for a while. We're still working out the details. That's fine. So thank you for your forbearance. Okay, your name, address, and your relation to the case.
My name is Kim Pang Lei, and I am the homeowner at 8644 Kings Arms Way.
Okay, thank you. Do you swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Chairman, forgive me. Could you state your name one more time, please?
Kim Pang, K-I-M-T-H-A-N-H.
Thank you so much.
And for ease of use, we generally call her KT. All right, so what I want to do is sort of run you through the process of how that we got to this point. So how long have you owned this current property?
Since 1999.
And have you changed the property anyway, the layout, the shape of the lot, or deeded off, or is this how you purchased it?
No. We bought it that way.
Okay. And you're one of the trustees of the trust that owns the lots? Or
Yes.
excuse me, the lot. And is your property subject to a homeowners association?
No.
What's the surrounding area like? Is it mostly homes? Is it well
Mostly
maintained?
home,
Are there a lot of children in the area?
yes.
Can you give the board just a piece of information about what the area was like before you started the improvements that we're talking about today?
Like our house is almost 10 acres and the house is all the way in the back. So we mostly don't use that area, but sometime when we go out there, we see like cigarette butts and beer cans and Coke cans. So we always clean it up. But then when we see the cigarette butt, we kind of like worry that it might like if it might burn and then so we asked the contractor to kind of like to put up a fence so that and then we hire Bill Pomarico to put up the fence and he improved it. So he planted a lot of trees, and I think after that, I think Bill would need to say it because after I hire Bill, I mainly just like leave it to him to do the work.
Did you think about fencing this area off?
Yes, because like there are a lot of children in the neighborhood, and they always ride the bicycle, and people walking by a lot, and we just. One of the insurance agents recommended me to fence it off because for the liability reason. And then I'm more concerned about the safety reason because it's over 10 feet from the street down to the stream. And children can get hurt with that. Even adults can get hurt if they're not careful.
Can we look at real quickly at Exhibit A on the front of the exhibits? And we've highlighted the lot itself that we're discussing. And does this block right here, the red with the arrow pointing it, does that accurately show the area we're discussing today?
Yes.
With the two streams running through it?
Yes.
Did you know before work began on this area that this was part of a stormwater buffer area?
We did not know because it is a dry stream, so hardly has any water in it.
Okay. Did you eventually end up getting a violation notice for the work that y'all started?
Yes.
And who was that from? Do you recall?
City of Raleigh?
Okay. Did you stop work immediately?
Yes.
And did you work with the City of Raleigh to develop a remediation plan to put the...
Yes.
Did you have help with that? Did they provide you with some documents and things?
Yes. We got lots of help from the City of Raleigh, especially like Ben Brown and Lauren Witherspoon. They actually came to the property and looked at the condition and gave us the solution how we could meet the requirements.
All right, thank you. And I want to flip over to Exhibit B. Is this the area that we're discussing as it sits today?
Yes.
Does that accurately describe the plantings and things that you have done on this portion of the property?
Yes.
All right. And this street that runs out in front of it, is this a fairly busy street?
Yes.
Is this where you were describing children going in and out?
Yes.
So they have immediate access to the area that you were talking about?
Correct.
And I think we said this one time already before, but you can't see this area from your house, can you?
Right, because we live in the back of the house, so the back of the land. So.
All right, and then turning to Exhibit C, is this the actual ditch that's just beyond those hollies?
Yes.
And it drops off fairly quickly?
Yes.
And then Exhibit D, just purely for demonstrative purposes, this is the same side of the street. These signs are throughout the neighborhood, which is just slow down kids that play. These are family homes. They're big lots, perfect for growing families. So there is a lot of children in the neighborhood. And Exhibit E, is that the fence that is currently in place on the other side of your property?
Yes.
And are you going to build if given a variance, are you going to build a similar fence to this one?
Yes.
And have you shown this to the folks at the City of Raleigh? Did they give you any guidance on it?
I think because it is an open fence, so it is a good choice.
It's not going to impede the flow of water?
Correct.
Turning to Exhibit F, was this the guidelines that you were given by the City of Raleigh?
Yes.
And did you use this to develop your planting plan?
Yes.
Can you tell us a little bit about the plants that you're including in your planting plan?
So on this guidelines for buffer restoration, on page 6, there are list of native plants. So when we develop the plan, we pick the plant out of this list. And then on page 10, it has the planting density. So we calculate the area, and then we just like follow this number in the guideline.
All right. And is that the planting plan that was submitted with your variance application?
Yes.
All right. Has part of this been planted yet?
I planted some, but some plant kind of like should be planted in the summer, and some should be planted in the fall, and some should be planted in the spring.
All right. And as part of your remediation efforts to put the buffer back, has everything been graded and planted and is back to where it was before?
Yes.
Did you adjust the stream height any?
No.
Did you have to install per DOT a extension of the pipe that ran through it?
Yes.
Is all that done?
Yes.
And did you hire an engineer
Yes.
to help you with obtain all the permissions and permits?
I think the contractor, like Pomarico Construction, obtained the permit, but John is the engineer that he come up with the certain documents.
All right, that's all the questions that I had for you. Do you have anything that you'd like to add before we move forward?
No.
I'm going to call my second witness.
Maybe we see if the board has any questions for Ms. Fang. Anyone? Okay, thank you. Yes, go ahead.
I'd call Bill Pomarico.
You state your name and address for the record and your connection to the
William
case.
Pomarico, 200 Annandale Drive, Cary, North Carolina.
Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Pomarico, can you give us who you work for and how long you've been in the contracting business?
I own the company 47 years.
And are you a licensed general contractor?
I am.
How long have you been a licensed general contractor?
In North Carolina since I think 95.
Can you sort of give us an idea of the scope of work that your company was doing on the property for KT?
Well, I would consider it to be landscape work, really. It was an area that was kind of unruly, and we went in and kind of cleaned it up a little bit and planted some material in an effort to make it look better.
Were you on site when the violation notice was given, or
I was.
do you recall when that was?
I do not recall the day, but it's a while ago at this point.
And I'm assuming, what were the things that the city of Raleigh asked you to do once you given the violation so we could restore the area?
They were just concerned about erosion control, and I mean, anything that they had was on the report, and then we followed the report.
So has all the area been placed back as it, not as it was, but as all the area's been stabilized, they're back into a finished state?
Yeah, so I mean, it was stabilized very quickly at that point.
Did you supervise the installation of the pipe extension we referenced earlier?
I did.
Can you tell us a little bit about why that had to be done?
After we cleaned everything up, the slope didn't really allow us to do what we needed to do. It was too severe, so by extending the pipe, it helped to reduce the grade. Or not reduce it, but at least reduce the slope.
So let me clarify that just so I know. Reduce the angle of the slope?
The angle of the slope.
And then as part of your, if we could excuse me, if we obtain the variance, would you be installing the fence?
Yes.
Can you give them, the board, an idea of how this fence is installed? Is it?
It's a fairly simple fence. It's all open, wrought iron. Every so many feet, there'll be a concrete, you dig it out and put a post in the ground, put some concrete around it. I mean, it's been noted, but the fence is well beyond the actual drainage ditch, and it will have no impact whatsoever on the drainage ditch.
Add it real quickly. Let's make sure that we are understanding. Now, are the posts for the corner of the fence already in? When I say posts, the columns that the fence attaches.
There are 2 columns that will anchor the fence, and those are installed.
Did you have an engineer evaluate those for impervious surfaces?
It's a negligible effect on the impervious. I mean, they're only like 2 foot by 2 foot on an almost 10-acre parcel.
Did you help with obtaining the permission from DOT and the Environmental Quality Bureau?
Any of the agencies that were involved, I went through the whole process and pursued the proper documentation that was required.
And all those were, I'm assuming these were the permits and the letters that we were including in our exhibits?
Yes.
I have no further questions unless the board has any questions.
Thank you, board members. Any questions for Mr. Pomerico? Okay, thank you.
Thank you.
As my last witness, I want to call John Callahan.
Name, address, and your connection to the case, please.
Yes, this is John Callahan. I work with JACO, John Edwards and Company Consulting Engineers, 333 Wade Avenue in Raleigh, 27605.
Mr. Callahan, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Callahan, can you explain to the board what your scope of work on this project was?
Yes, after the violation, I was brought in just to evaluate some of the work that had been done and then prepare the plans for permitting in conjunction with to rectify the violation. The pipe extension had been completed, and we had multiple meetings with NCDOT. I provided calculations to show that the extension of that pipe met all their requirements and got the proper approvals for that. It was a pretty big crater at the outlet of this pipe, a little bit of washout, and so just one joint of pipe extension did make that the slope much more stable.
Did you perform a survey of this area?
I did. So we've had our surveyors out to locate the existing fence columns, the property, and the stream bed, as well as the new pipe culvert, so we could show it accurately on this plan before you.
And are the hatched marks that run here, like there's an exhibit I, which I want to show you. I have to take my glasses off. You may have to put yours on. Can you sort of point to where the plan would, or the fence is planned to go?
Right along here. That's actually closer to the right-of-way than what I've just drawn, but that was where it's going.
In your opinion, is this going to impede water flow for the stormwater buffer in any way?
No, this is well uphill of the stream bed.
And Mr. Pomerico had testified earlier that there's minimal concrete going in. Have you looked at how this might impact the impervious surface calculations for this property?
Yeah, generally fences don't make a lot of impervious area. There are some columns involved with this, but at 4 square feet per column, it is a negligible amount of impervious area.
I have no further questions.
Board members, for Mr. Callahan, questions?
I have one.
Please.
Did your insurance company or the owner's insurance company have a recommendation about how high of a fence you should construct?
They asked for it to, she's still considered under oath?
Yes.
I know there was a recommendation. I don't know the specifics about what the recommendation was.
No, they just say that it's
Can you
better.
come over here and speak into the microphone, please?
So they just say that it's better for you to have a fence so that keep people out, so you don't have to deal with liability issues later.
Yeah, it would just seem that it should be a certain height to make certain it's effective. That was just my question.
The current fence would be roughly at the top 6 feet, but the primary part of it would be right at 5, which is common in the neighborhood and would be consistent with what's in the neighborhood. And then there's, as I mentioned previously, there's already an existing fence and gate that goes around the front of the property. This is the last corner that has not been fenced in until you get back into the back part of the lot, which there's nothing behind it.
Okay. Other questions? Okay, thank you.
So to wrap things up, realistically, what we're asking for is what the standard says, that by a strict application of the UDO provision, my clients are going to face the hardship of potentially having to constantly keep people out of the property to deal with the trespassing and potential liability issues. And we believe the establishment of this fence goes along with the spirit of the provision in that it will not impede or block in any way, shape, or form stormwater getting to its designated areas. And in fact, we kind of thought that maybe some of the larger pieces of trash would not end up in the stormwater because the fence will block it, such as plastic wrappers, things of that nature, bags. Obviously, the bit smaller stuff's going to get through the wide things, but we believe it's going to place an undue hardship if we're not able to fence in this area. So we would ask that the variance be granted, and I'm happy to answer any other questions that you may have.
Okay, thank you. Any questions?
Thank you for
Okay.
your time.
Yes, sir, thank you. We'll invite the public now. If anyone here wishes to provide factual testimony concerning this request, you're welcome to come forward. Anyone? Okay, hearing from no one, I guess there's no need for rebuttal at this point. Staff, Mr. McDonald, anything further from you? No, thank you. Okay, board, anything else in the way of questions? Okay, then, having no additional questions or presentations of relevant facts, the board will now close the hearing and bring the matter to the table. As a reminder, this board is tasked with deciding if, based on the evidence presented, this proposal meets the applicable standards. This decision cannot be based on personal preference of board members. Rather, it is based on standards and evidence. If based on its deliberations, the board requires additional evidence, the board will reopen the hearing. So I'll entertain some commentary or a motion. Are there still questions?
I may have one, yeah. I'm looking at the exhibit, I believe it's the second page of Exhibit C, and it has the approximately 6-foot strip of grass and then the pine straw, which then goes down to the watershed. I can't quite see exactly where this proposed fence is gonna go. Is it in the green, is it in that green strip of grass? Is it beyond it?
Before you answer, we'll need to reopen the hearing.
Yeah.
So by the approval of the board, let's reopen the hearing. Heads nodding. Thank you. You may answer the question, please.
If you don't mind, I'm going to grab it.
Yeah.
Real so though. You said C?
Yeah, there's a second page C where it says, please drive slowly, children playing.
Oh, okay.
And then you have, E, which has the fence and all that. I just want to get a better idea of where that fence is going to go as it relates to the grass and the tree line that's there.
Okay. It's right in front of the hollies.
It's right in front of the, yeah, okay. But on the,
If you look at Exhibit B,
yep.
You have a row of pine trees,
Yep.
right? And then there's the mulched area.
So you're saying in between the pine trees and the holly?
Yes.
It'll be very close to the holly.
Okay, that's fine, okay.
So just to follow up to Mr. Coach's question, I guess technically, how many feet from the side, from the asphalt in, is what would it go in?
From the asphalt, where the fence will be,
Yes, sir.
I would say that's probably somewhere in the neighborhood of 10, 12 feet.
And I would remind everyone, because we do record this, pay attention to using the microphone so the tech crew can pick up everything that's being said. Any other questions? Anyone? Okay, if there are no more questions, then we will again close this hearing and move it to a board discussion or an offer of a motion.
I guess the only question I have ongoing, like, I mean, I guess it's within the primary watercourse buffer, which we may allow. This is going back to Catherine, do we have to put anything in there regarding maintenance thereof, or gets hit? I mean, there's nothing on the city by allowing this that they have to maintain it. I mean, I would assume that's on ownership, correct?
I would actually defer that to Ben Brown, Stormwater Administrator, for his input on that. And I believe he's here.
Sure.
I don't know the answer. So you can open the evidentiary hearing, swear Ben in and ask him that question.
I think we got to get, I mean,
Then
if something happens to it, then, and we've allowed this today.
Yeah, I would get to Ben as to whether there's any stormwater regulation I'm not aware of that requires maintenance. I'd also point out that there's currently no conditions imposed on the variance, or you haven't discussed any, but that you can impose conditions.
Okay, let us, with the approval of the board, reopen this hearing. Mr. Brown, welcome. Do you swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Kuntz, your question?
Okay. Hope I did. So if I mess it up, let me know. As far as a maintenance requirement for this revegetated area, there is not a code mandated maintenance requirement like you would see for like a stormwater device, where we get like an annual inspection on a stormwater device from the property owner. But if we were to inspect the property and the planting wasn't taking place, then we would tell them to go back and put the planting back. But they're not proactively sending us maintenance reports.
There's no real assumption from the city of Raleigh that would have to maintain any of that.
Oh, well, I mean, there's assumptions you have to maintain. It's just they're not sending us that yearly report like they would with a stormwater device.
All right, we're good. Thank you.
Thank you, Mr. Brown. While we're still open, any other questions?
May I add
Yes, sir, you
one
may.
other thing? We also, as part of our agreement with DOT, when they did the extension, we have made an agreement with them that to the extent DOT needs to maintain that area, we are going to remove the fence and put it back at our cost. Then there will be a gate so they can access the fence as well, and presumably, to the extent it's locked, they would have a key.
Okay, thank you. Again, board members, other questions? I am going to close this evidentiary hearing again, and let us move to board discussion or a motion.
I'm motion to approve.
We have a motion to approve. Is there a second?
Second.
Thank you, Mr. Butler. We have a motion to approve and a second. Further discussion? Then, Mr. Puccini, we do not need to do a roll call vote this time. We can actually vote. Okay, so all those in favor say aye.
Aye.
Any opposed say no. We have an approval. Thank you very much. Thank you very much for your time today. Okay. Let's move along to our item B on our agenda. This is BOA 0027-2021, 2508 Glasscock Street. This too is a variance. Mr. McDonald, welcome back.
Thanks. So this request is two parts. The first portion being a 5-foot variance to the side lot line setback requirements set forth in 221B3 of the UDO, and an accompanying 2.2-foot variance to the sum of side setback requirements set forth in UDO section 221B4, a detached house on a 0.27 acre property zoned R6 located at 2508 Glasscock Street. So I'll proceed over to the plan document. I think that gives the best understanding of what's being proposed. And first, a little bit of background. It's my understanding this specific variance was spurred first by a zoning enforcement action that took place last October due to what at that point was a detached car shelter, carport. The applicant was unaware of the requirements to get zoning approval for the structure, and so at that time they were made aware. The detached structure did not conform with the accessory structure requirements set forth in the UDO, and so at that point they were advised the only way to move forward would be if the structure was attached. there appears to be some miscommunication about process in that the structure was then subsequently attached prior to receiving approval from the board or prior to this case being heard by the board. And so the structure, as I understand it today, is attached to the principal dwelling on the property, and I do have a few photos to show. But this particular plan document is accurate in terms of the scope and extent of the car shelter. So again, it was originally a carport, meaning more or less open on, I think, 2 or 3 sides and detached from the house. And at this point, it is attached and considered part of the principal dwelling for purposes of setbacks. So the required setback on this property line is 5 feet, same on the opposite property line, and then the required combined setback of the two is 15 feet. So that gets you to the 2 portions of the request. As you can see from the survey, the corner of the car shelter towards the rear yard is very close to the side property line, only about 0.1 feet off. So for purposes of the advertisement, we made the request for complete relief. And I will show just a few photos to help contextualize. This is photos submitted by the applicant's attorney recently, showing the structure attached or being attached to the principal dwelling. And so staff does have a few comments related to this particular request. First, a variance standard number 1. Staff's comment is just to note that there is no guarantee under the UDO that every residentially zoned property will be able to accommodate a garage, in this case, an attached or detached garage. Many homes in the vicinity do not have garages for the cars that are parked on site. They're just parked in the driveway. So it does appear to be a relatively common condition in the neighborhood to not have a kind of shelter for a vehicle on site. To variance standard number 2, staff notes that while the lot may be irregularly shaped, again, many of the homes in the neighborhood do not have garages and rely on driveways for the parking of vehicles. And last, to variance standard number 4, the building setbacks are intended to provide adequate spacing, privacy, and daylighting between structures and properties. In certain residential contexts, setbacks also allow for ease of access and proper maintenance of property boundaries and adjacent structures. Locating an attached garage at or near the property line could have a negative impact on the neighboring property and could make maintenance more difficult. So that was staff's comment related to the spirit, purpose, and intent being met by this specific variance request. So that completes my presentation. I'm happy to try and answer any questions at this time, and if not, I can pass it off to the applicant.
Okay, thank you. Board members, questions?
I've got one. So if this was detached, would it trigger this?
Yes. Yes. There's a caveat with that. The accessory structure rules in the code are one of the only sections in the UDO that can actually not be varied via a variance. And so that's pretty unique. Most everything else in the code, with a few other exceptions, can be varied. And so there were specific provisions included in the accessory structures section when it came about 2 or 3 years ago that allowed essentially for certain types of attached structures to be considered part of the principal structure. So essentially, there was allowances made for certain types of breezeways that met specific criteria. That if you connected an accessory structure to your house with a breezeway that met certain width and height limitations, they could still be considered detached from one another. In this case, they're fully attached and they violate those breezeway standards, so they're considered one principal structure, and the entire thing, while it looks kind of separate from the street, has to abide by the principal structure setbacks.
Other questions? So in terms of the connection, the permanent connection, is there a way, could it be reduced in size and meet our expectations, or is it any connection would trigger this concern?
So the caveat is that even if they were to reduce the connection, they would actually be prohibited from requesting a variance at all because it would be considered an accessory structure, and none of the accessory structure regulations, including setbacks, can be varied. So really attaching it was their only way to then get to this point and request relief for the setback.
All right, thank you. Questions? Okay, let's move to the applicant then, please. And please introduce yourselves, name, address.
Randy Herman, attorney with the law firm of B.A. Folk. I'm here representing the applicant, Mary Overby, and the applicant is here as well.
Thank you.
Do we want to go ahead and swear her in?
Sure. Ms. Overby, if you would step forward and state your name and address for the record.
I'm Mary Overby, 2508 Glasscock Street, Raleigh, North Carolina, 27610.
Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do affirm.
Thank you.
All right, so I'm just going to give a quick overview of the case and then ask some questions of the applicant. So, as staff mentioned, given the location of this structure, this carport, as a detached structure, it is in violation of the UDO and is not eligible for a variance. As an attached structure attached to the house, it then becomes part of the house and is eligible for a variance. So that's why we decided to proceed in that way, just to get clear on that question. In addition, I wanted to note that although technically we do require a variance from the side setback and also a variance from the combined setback, as you probably know, last week council passed the missing middle text change reform, which does eliminate the combined setback requirement. That technically doesn't go into effect for 30 days. So for right now, we are still required to get that variance. But if we were here next month, it would be a moot point to whatever extent that matters to the board. All right, so I'm going to ask Ms. Overby some questions, and then at the end, I will summarize the standards under the ordinance. So you are the owner of the property at 2508 Glasscock?
Yes.
And can you tell us why you decide, well, hold on, let me do some pictures real quick. This is an accurate picture of your lot and the structure on it before you put up the garage?
I can't see what you're saying.
Okay. So this is the street here, Glasscock?
Glasscock, yes.
So this would be the front of the house?
Yes.
And is that an accurate picture of what the house and the shed look like before that? All right. This is a satellite picture. Clear that. Again, is that an accurate picture of the house? All right. And this is a survey you had done, is that right?
It's one of them they had done too.
Right. So this area that's outlined in red on that survey, is that the location, an accurate picture of the location of the carport and the attachment?
Yes.
Okay. So tell us why you decided to put a carport in that location.
I had been needing one after 36 years of being there. When I bought the property, I had been needing one there for bad weather. When there is, in the winter, ice and snow come, I have slid down because the driveway and land is like a hill. If it get icy, I slide down, but the cover keeps the ice and water out from us stepping out, sliding down the hill. I got scars from my knees from falling on ice, so now I can get out my car and me and the kids, we don't worry about falling, and my grandkids.
Did you consider putting it anywhere else on the lot other than that location?
Yeah, they looked around the back and other side, and they said that because my driveway had been there for so many years, it was okay to put it into my driveway. So it's not on land, it's into the concrete of my driveway.
So you just put it on the existing driveway?
That's right.
Now, this survey also shows a fence running along the property line.
Mm-hmm.
Is that accurate? There's a fence there?
Yeah, that's part of a fence there.
Okay. And then we have a couple of pictures. Are these accurate representations of what the structure looks like under construction?
Under construction, yeah.
And then this is what it looks like now?
Yes.
Okay. That's all the questions I have. Do you have anything else you wanted to add?
Yeah, since I put up my carport, about 3 or 4 neighbors have put up one, and theirs is not attached, and when I called and asked the zoning, they said it's only matter if the neighbor complains, so I had a complaint. But the other neighbors haven't had complaints, so that's why I'm here.
Do a lot of people in your neighborhood have carports like this?
About 4 had it before I did it, and now I've seen 3 more new ones come up. They're not attached, though.
All right. That's all the questions I have. If the board has any questions?
Board members, any questions for Ms. Overby? Okay, go ahead.
All right.
We done?
Yeah. Unless they have any other questions, if you just want to sit down. So I just wanted to quickly address the 4 elements required to be shown for a variance. Staff has stated that you don't have an entitlement to have a garage on your lot. That's obviously true, but the question is not whether every property owner is guaranteed to have a garage. The question is whether for this lot it would be a hardship for the property owner to not be able to have a garage, because as we've covered, there is no other place on this property where it would work for her to have it, and she located it in this location because it was on the end of the driveway. She was able to secure it into the driveway, and so that was the best place to place it. Again, all she's asking for is to be able to keep this small carport there, and under strict application of the ordinance, we don't believe there's any other location on the property where it could be placed. As far as conditions that are unique to the property, as we put in the application, that her lot is both narrow and wedge-shaped with a smaller area at the back. This required that when the house was built in 1969, it be placed forward on the lot and at the center of the lot, which reduced the area in front of the house, and also because it's centered, there's very little room on either side of the house. It's a combination of the size and shape of the lot and the placement of the house that really restricts what else can be placed on the lot. If the house had been designed with a garage, obviously it could have been placed over to the side. The garage could have been placed on the other side. It would all fit, except at this point, there's a house there, and there's been a house there for 50 years. And again, the conditions creating the hardship date from when the lot and the house were created in 1969. So it's not anything that was created by the property owner. The final question is as to the spirit and intent of the ordinance, substantial justice. So the only concern that staff has expressed is that there be fire and emergency access to the rear of the house. If we go back to the survey, so as Ms. Overby stated, there's currently a fence that is located right on the property line. So she is allowed to put a carport or any kind of structure up to the property line. So there's really only a 5-foot setback there in which any kind of access could be done. So because the fence is located on the other property, it's not like any kind of emergency vehicles or anything would be able to come through that 5-foot space. So it doesn't appear to us that allowing that carport to be there is actually going to have any kind of negative impact. And if there were a requirement at some point to actually access the back of the lot, There's almost 13 feet on the other side of the house. There's a bit of a driveway that goes up there, and that would be an easy source of access if it ever were to be required. So our submission is that it's not going to have any kind of negative impact on health and safety, or any kind of negative impact on the neighboring property or anything like that, as compared to what she would be entitled to do anyway under the ordinance. And as she stated, several other houses in the neighborhood have similar carports, so it's not like she's asking for an entitlement that is different or greater than what anybody else has in the neighborhood. That is all we have, and unless the board has any questions for me, I'll rest on that.
Board members, any questions? Okay, thank you, Mr. Herman. We'll now open this up for public comment. As a reminder, witnesses should provide factual testimony as to how this project does or does not meet the applicable standards. Anyone wishing to come forward? Okay. Once you get to the microphone, would you please, again, introduce yourselves, give us your address, and state your relationship to this case?
Yes. My name is Ruth Elaine Tucker, 2504 Glasgow Street, Raleigh, NC 27610.
Okay. And sir, did you want to go as well?
My name is Glenwood Dobbin, and I live with 2504 Elaine. We live together.
Okay, great.
Yeah.
Thank you.
Did you
Yes, ma'am.
administer the oath?
I did
to
not
them?
yet.
Okay.
Yeah, just getting them sworn in. Ma'am, first, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. And sir, likewise, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Go right ahead with your comments.
You me start?
Whatever.
Okay. I don't know how to bring that screen up y'all had a while ago that was showing the diagram of the garage.
I can pull it up for you.
Yeah.
Yeah.
Okay. The red diagram right here.
And you could just use these two.
Yeah. Okay. As you see right here, this is her the line. What you're looking at right down that red line right there, running to the rear of the house, which goes in an angle like this. But if you see the garage is all the way across the line where it's supposed to be property line. You see what I'm saying now? She crossed the property line. Because if you look at the red line, she done crossed over the property line, would run down beside the house we live in and her house. And what we're saying is this right here. How you gonna sell the property when she done got over on the property, taking property from us? You understand what I'm saying now?
I understand, yes, sir.
Yeah, because that's gonna devalue the house when you see somebody else's attachment over there on our land. See what we're talking about? It's not my land, it's her land, but we plan to unify this here between me and us.
Excuse me, I'm just gonna.
Oh yeah.
And the other exhibit, I think, might give a better zoomed in view. Yeah.
And sir, I do have something I need to say also. Due to the fact of the car garage being there so close to my house, see, they didn't show the between my house and her house. You follow me? That's the most important part that it is, how close it is to each other houses. My concern is a fire hydrant. You know, I'm looking at it, if anything happened, this is an easy way of my house catching a fire much quicker if hers catch. You follow me?
Yes, ma'am.
That's my concern just as well. Okay?
Thank you. Anything else?
Dennis, I want to ask y'all this here. I was listening to him saying a while ago about the that code 2 whatever it is right here. And I thought when I looked online with it, it's supposed to be back so many what they call sideline, right? Ain't it supposed to be 5 feet from the property line? When you put an attachment like that still?
Normal standard, yes, sir.
Yeah, well, I was looking at that. Then you go to the setback, which is supposed to be 15 feet setback. You know, according to the R6 reading and all this stuff, yeah. I saw that online. That's why I was asking, how is it that she can put the structure there and just come over the line, she is over the line. If you go out there and look and get a survey to come out, I'll pay for that myself. But I know she's over the line when I showed you that little red line where the garage was. Yeah, that's over our property line. You know, see what I'm saying now? So that's a devaluation of the house if you try to sell it, right? Hold up. And
Anything
well,
else?
basically, that's what I have to say about it.
Okay.
I mean,
Thank-
I try to be a good neighbor, but it seems like I can't be one. That's all I'm gonna use.
Understand, thank you. We're allowed to ask questions, so anyone have questions of the witnesses?
Yes.
Ms. Rudisill?
Yeah,
Microphone, please.
Sorry?
Microphone, please. Just,
Is your objection to the fact that they're trying to put the carport there, or just to the encroachment?
It's just the purpose of being safety also. You know, like I pointed out a while ago, you know, you have to look at fire hydrant situation. You know, that do play a role too, of building so close. You know, you got to understand, you know, other people that stays there too.
And the question you asked just now, can you ask that again now?
I said, was your objection to the carport in total, or just to the fact that it's encroaching?
Well, if you ask, this is my opinion. I don't think it's a good carport for the housing development over there to start with. It looked like a boat housing carport, really, to me. It looked like you put a boat up under, so it don't look like a regular carport that you would normally see. We have a carport, but it's onto the house, though. You know what I'm saying? But if you look at her, you didn't get the whole view. You just saw one side inside, not to the outside. You just saw that inside part, right? Yeah, but it's another section to the side that you ain't seen yet. That's what I'm telling you about, where it's over the line at, where I done did the little, well, she had a survey, which I got all the markings and all this stuff, and in the back too, like y'all saw that little red line that came across. That's the whole point we asking about, because we're thinking about maybe selling the house. And how you gonna sell it when you got some property over there on your land to sell it to someone else?
have other questions from the board? Okay, thank you for coming forward,
thank you.
appreciate it. Anyone else here wishing to speak to this case? Mr. Herman, you have an opportunity for response.
Thank you, Mr. Chair. The neighbors have claimed that if a surveyor came out, that they would find an encroachment. This is a certified survey that was done by a surveyor. It shows that there is no encroachment. The edge of the carport is close to the line. It's less than less than a tenth of a foot from the line, but it is not over the property line. It is entirely located on Ms. Overby's property, and that's already been verified by a surveyor. As far as the fire safety concerns, we would just point out that the neighbors are the ones who put up a fence that is already located on the property line. So, as I said, even if Miss Overby put a carport that just went to the setback line, there would still only be 5 feet between that existing fence and the carport. So it doesn't appear to us that having the carport at its current location as opposed to having it at the setback line really makes any significant difference in terms of access or safety in the case of an emergency. So that would be our submission as to that.
And when was that survey completed?
This survey is dated, let's see, of 2021.
Other questions?
Yeah, but they didn't measure anything else today.
Okay. And that's your final comment on this?
Yes.
Thank you very much, Mr. Herman. Mr. McDonald, anything further from you? Ms. McDonald, anything further from you on this?
Not at this time.
Okay, great, thanks. Then we will close this hearing and move to our deliberation at the table. Any other questions from the board, discussion? You can think out loud about this one. Help us reach a resolution.
I guess according to the survey, it's within the guidelines, but then I guess the next question is as an overhang at the top of the of the garage. So would that come into play if there's an overhang where it hangs over, even though it's, the bottom is basically within the guidelines? So then if there's, would the top of the shelter be over, and would that cause an issue from a property owner's perspective, from a neighbor? Not sure how that plays into.
Ms. Hill, do you have an answer to that?
It might be helpful to ask staff about the permitting process, because I'm not sure that they would allow a permit if it encroached into a neighbor's property, but I would get confirmation of that from staff.
Okay, let's
Justin or Keegan or whoever you think.
Thank you. Let's reopen the hearing so we can get clarification on this. A good question, Mr. Butler. Mr. McDonald or Mr. Rometta, I'm not sure which of you can answer this, but regarding the potential overhang from the carport, is that considered an encroachment, and is that allowed? Or is it just the base measurement that is at issue?
I was actually looking quickly at the general encroachment allowances that are made for building features. And in all instances, those are just allowed to encroach further into a required setback than would otherwise be permitted. I'm not aware of any allowance for a building feature to encroach beyond a property line. I don't believe that's something that would be permitted under the code. I was looking at the zoning enforcement case for this particular item. I'm not sure where it stands in the permitting process. It's my understanding when originally constructed, they did not receive either a zoning permit or building permit for its construction. And so this is being done in effort to remedy the outstanding zoning issue. But I cannot say with certainty where it would fall in terms of building permitting, and if it would be approved as constructed, either as it relates to structural integrity or some other potential issue. But I'm happy to look in the zoning case and see if there's anything else I can locate.
Do we know, and maybe the pictures reveal, I'm not sure they do, if there is overhang? Can we tell that from any of these photos?
Let's pull that picture back up.
And if I could ask, this is the variance to allow the use, but they would still have to get a building permit, though, if that's my understanding.
Yes, they would have to ultimately go through building permit. It's just that I can't say that they've made any progress towards the building permit at this stage, or gone through any type of building permit inspection at this stage.
So if a variance were approved, this might still later be deemed inappropriate through a building permit process?
If the structure was deemed to not comply with the plan document that's been submitted as part of this variance that shows it's totally within the bounds of the property, then yes, I believe so.
Mr. Butler, any follow-up?
No, sir.
Yeah, and unfortunately, these are the two images that we have, which only show kind of the interior. So I can't say with certainty what the exterior portion of it looks like, where that potential overhang might occur, or if one even exists. I can't say.
Sure. Okay, we're still in the open hearing here. Mr. Herman, do you want to respond to anything that you've heard?
Yeah, I just wanted to speak to the building permit, where we are in that process. There was an original inspection that was done. Because it was in violation of the setbacks, the permit was denied for that. So right now it's just being held pending the results of this hearing. If the variance is granted, then the building inspector would have to go back and inspect for structural integrity and all those other things. And so yes, if the building were over the property line, then it would be denied for that.
Okay, thank you for clearing that up. Anyone else? Okay, then let us close the hearing. Thank you for the additional information and go to discussion and a potential motion. And it sounds like the building permit process may yet answer the question about inappropriate overhangs if they exist.
It's a tough case. I mean, especially when you have something already built or in the process. But in instances like this, I like to go back on the intent of these setbacks. I mean, they're there for a reason, for the reasons that we know, and also that were disclosed today by the not the applicant, but those who are standing against the applicant. In the real world, you hope this stuff gets worked out between two neighbors, I'm certainly not gonna usher that conversation, but, you know, ultimately, if you gotta, the rules are there for a reason. It's unfortunate they were not circumvented, but they were done without, you know, application of those rules. I don't have a solution, but I'm pretty clear that this is an infraction, that, you know, if you have, I mean, in the end, it's gonna be hard for me to say yes to the applicant when there's rules and regulations, you know, that they're asking for forgiveness from, when we have those rules there kind of for a reason. That makes sense? I mean, this is tough. It's very tough, and especially when you have something that's already vertical. And I don't know what the ultimate solution is, but certainly maybe after this, our vote today, that we can, you know, they can figure something out. But to me, I think it's a clear violation. I can't get around it.
So, and also, did I hear the applicant say that if we vote today, that the permit application is hinging on our vote today? Is that because it was still denied, and they're still waiting for a decision from us? Is that correct?
As I understand it. We have, appreciate your point of view, Mr. Kuntz. We have certainly allowed variances in where things have already been done, not necessarily to this degree right up to the property line. So it's a question of can we allow the variance or not. I take some comfort in the building permit process in terms of the potential overhang, but there's no question that this is would be a significant variance within 1/10 of a foot of the property line. Bill?
So, again, that would be addressed at the building permit stage. So I don't know what you could do. It's always in this circumstance, since you opened the hearing, you got to this point. If you wanted more information, you can tell the applicant. It's their decision if they want to ask for a continuance or not. You can say, you know, if you wanted to vote today, here's maybe how I would vote if I didn't have this information. If the applicant wants to continue the case to get you that information, it's up to them to ask for that continuance, and you guys can decide if you wanted to grant that or not. But I think staff's position also is that, but if I understand it correctly, at building permit stage, they will not be issued a building permit if it encroaches into the neighbor's property. So I don't know that if you have the answer, or you have the information today to show you that, but I think that you've been given that information from staff. So.
Okay, Mr. Kenny?
I still think there's that outline, that there's an overhang, it could be infringed, there's a survey question, which I think there has to be, there's some onus on the parties to figure that out. I still think that it goes back to, you know, we do grant variances in those setbacks from time to time, but it's when there's multiple parties and they're all happy with it and we have people to come and voting support with it. It's just hard for me to allow another instance like that when we know that the direct neighbor is not happy with it. Now, perhaps there's something that can be done that they're willing to overlook that. I'm not getting into that, and that's not our job to get into that. But today, it's like there's a variance there for a reason. You have a neighbor that's unhappy. The fact that it's going to encroach on that, the fact that it overhangs or not, or wherever it is, like we know whether it's 5 feet or not. Like that's problematic, and I can't get behind it if the neighbor's unhappy. And that's just where I am. And I think it's extremely unfortunate that it's up and it's come to this, but that's where my head is.
Okay, very good, thank you. Anyone else wish to offer an opinion, a thought?
I agree with what John, we have to consider what the neighbor adjacent thinks. And it seems to me if we just like let the building permit people take another look at this, we're just kind of not taking responsibility for what our decision should be. We should make a decision. And it concerns me that the neighbor has concerns. So.
Okay.
And I almost specifically continue it and let them work out something and come back. But that's not, I mean, I'm hopeful that they all work something out, but I'm not going to put something like that there. But
and I guess to your point too, Mr. Kuntz, that, you know, of course, if it's devalues the neighbor's property in terms of selling it as they talked about, so then that's a concern as well.
Yeah,
if that's the case, if it's going to be a a hardship on the neighbor, that we're gonna create a hardship for an adjoining neighbor, you know, and then we're not in that business to do that.
Yeah, I get it, both sides. I think it's tough. It's tough for Randy, it's tough for the applicant, tough for Mary, it's tough on the applicant, but am I in good conscience, knowing the light of all that we've been told today, gonna sit there and say, to heck with the code, and we have an upset neighbor, am I gonna put my name on that? The answer is no, not today.
Right, understood.
Mr. Herman, you're getting a reading of the sentiment of the group, and is a 4/5 vote required. I'm not seeing that right now. So we can continue it to our vote, or if you wish to ask for a continuance, the idea that, again, what you're hearing is there a chance to work something out to the mutual satisfaction of all parties?
Yeah, we would ask for a continuance to next month's hearing.
Okay, do we need a vote on that, Ms. Hill?
You do.
Okay.
I think that'd be a good idea.
Yeah, excellent. Okay, thank you. We will, it's been requested by the applicant to have a continuance till our next August 9th meeting. I'll state that as a motion in a second. Mr. Kuntz?
Second.
So
Motion, yes, sorry.
Yes, thank you, sir. All those in favor of the continuance, say aye.
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 Any opposed, no. Okay, thank you, Mr. Herman. We're going to, Ms. Overby, we're going to continue this case for a month, and again, if there's a chance to work, you'll get a chance to confirm anything with the neighbors, the encroachment question, but anything that might help you get to the finish line, we look forward to seeing you next month.
Thank you.
Thank you.
August 9th, is that the date?
Yes.
Okay, great.
Yes.
Thank you. Okay.
Chair Swing?
Yes, sir.
I just wanted to verify if there was anything else specific you wanted from staff prior to the August 9th meeting. If there's any additional information we could potentially provide that would be helpful to the board.
Depending on what they come back with, I would suggest some more visuals from the other side of the, to really talk. I mean, we see what's going on here, but, with the point of friction is the other side of the building.
Yeah, okay. That's helpful.
That doesn't come from you, that comes up from the applicant.
Yes, okay. Yeah, and I was able to locate the building permit in our system, but it was for when the structure was detached. And at that time, most of the comments were zoning related, so that there weren't any building permit specific comments.
Just making sure that any additional evidence will be at the evidentiary hearing. So I think you're fine.
Okay, thank you. Let's move along to our next item on today's agenda, BOA 0028-2021. This is 1208 and a half Garner Road. This is a variance as well. And I believe Mr. McDonald is with us on this one as well.
All right. So I'll just note before I get into the specifics for this case that this and BOA 29-2021 are very similar. They are separate projects on adjacent lots, but very similar facts. So I'll be brief in that follow-up presentation as it generally mirrors what's the case with this one.
In that regard, we have in the past heard both cases' information and voted separately. Would you recommend we try to do that as well?
It's up to you. In those circumstances, if my recollection is that it's usually the same development that maybe involves several different parcels or types of requests. In this circumstance, I believe it's two separate developments. They just have the same property owner and probably the same hardship request, but they do need to be voted on separately. I think you could do them separately and be quick, but okay. I think that might be cleaner.
Okay, good. Thanks. Thank you. Okay.
All right. Thank you. So this is a request for a 6.66 foot variance from the front yard setback requirements set forth in 543 F18E of the UDO, which states that the front yard setback for the South Park NCOD must be within 10% of the average front yard setback established by buildings on the same side of the block face of the proposed building, but not less than 8 feet or greater than 30 feet. And the request is made in order to construct a detached house with a 25.4 foot front yard setback on a roughly 0.11 acre property zoned R10, and again within the South Park Neighborhood Conservation Overlay District. The specific address for this property is 1208.5 Garner Road. So here's the zoning, as you can see, zoned R10 within that specific overlay. So the neighborhood conservation overlay districts are intended to provide the highest level of zoning regulation and protection for principally residential districts. And so in this particular case, the NCOD sets forth specific guidelines or rules related to the front yard setback. So similar to how our infill compatibility regulations work, there's a specific methodology to determine the appropriate setback for any particular lot, and that requires a sampling of adjacent properties. And as you can see from this survey document, if you're able to zoom in on the bottom right, there is a table which kind of shows the adjacent front yard setbacks and the minimum and maximum setback. And they were able to those measurements that were shown were originally from the corner of the property to the easement, and the revised kind of plan document shows the actual true setback here, which is from the corner of the home to the actual right-of-way line. So this property, Garner Road, I believe, was widened, and they at one point dedicated an easement, which is kind of shown in hashing, in anticipation that part of that property would be taken during the widening. However, that easement is still there, and the true right-of-way line is here. And so the setback that's in question is here, 24.9 feet. And so the applicant is requesting roughly 6.5 foot variance to this front yard setback requirement relative to the sampling that was done on adjacent properties. And the principal reason for this request is related to an electrical utility easement that's shown. So the interior edge of the electrical utility easement almost forms the edge of where the corner of the house is being proposed. So there is obviously limitations on what can be built within the electrical utility easement, including how close the house can be to the right-of-way line, which is a little outside of what would otherwise be required by the NCOD. So those are the facts of this particular case. Staff does not have any comment on these particular setback provisions, or excuse me, the setback variance, or the variance responses that were provided by the applicant. But we are here to answer any questions you may have, and if not, I'm happy to pass it off to the applicant.
Thank you. Questions? Hearing none, let's move on to the applicant, please.
Good afternoon, Chairman Swink, members of the board. Really good to see you all in person. Was asking Eric just to make sure this was y'all's first meeting. It's been probably 18 months since I've been in front of y'all in person. I'm a lot hairier now. So Toby Coleman, 150 Fayetteville Street, for those wondering. Yeah. I will go pursuant to the city attorney's advice. I will go one by one. I'm going to start with 1208.5 Garner Road. Just as background, as Keegan said, the issue here is that that there is what's known as a front yard setback requirement in the South Park NCOD. Front yard setback is not actually a defined term in the UDO. It's principal street setback, I believe, is the correct term, and Justin can correct me if I'm wrong. So this is actually an interesting case where there's two houses, and I was actually asking, with me today is Sean Donovan of Concept 8, and he can answer any questions as needed. But I was asking Sean about this. So 1208.5 went through the entire process and actually got permitted. So he's got a permit, he just hasn't started building. When he went to pull the permit for 1208, which is another townhome, and he's already built these 3 townhomes here, that's when this issue came up. So this is sort of an issue where not even staff was 100% clear on it. One reviewer said one thing, one reviewer said another. Long story short, as Keegan said, the NCOD for South Park has a average setback requirement. Basically, they want to make sure that you are set back roughly about the same as all the other homes on your side of the block. As Keegan indicated, here's sort of a picture of the existing 3 homes that Concept 8 is built, along with with the foundations showing where the other homes will go. The goal here is actually to make them consistent setbacks. This is a block that doesn't have sidewalks. The homes will be roughly set back about the same distance from the curb as all the other homes on the block. What's creating the issue here? Here's some more pictures, just to give you a sense of things. What's creating the issue here is an easement. So this easement, so the city of Raleigh, in its infinite wisdom, took on the northern side of the block, took an easement that's about 10 to 10 and a half, 12 feet on 1208 and 1208 and a half, a right-of-way easement on the front side of those 2 parcels, and then bought in fee the right-of-way on the southern side of the property. So what you have basically is on the, it's accurate that the buildings on the southern part of the block are set only 14 to 15 feet back from the right-of-way line, but that's because the right-of-way line is about 10 feet behind the curb. These two properties, and I guess I'm talking about 1208 and a half, these 2 properties, their property line is on the curb. So basically what you have is a unique situation where, because of the way that the city of Raleigh took ownership of the right-of-way, you have a greater distance basically from the curb and the right, there's a differential that really isn't accounted for in the NCOD. So if you really wanted, our contention is that in order to maintain the even setback as desired by the NCOD, we need a variance as requested to permit that these homes be built about 6.5 feet further back than would otherwise be permitted. The end result, as you can see here, is that you end up with homes that are set back 25, 26 feet and 24.5 feet back from the curb, which is consistent with all the other homes on the block. And again, this is a unique hardship based on sort of a unique sort of approach to right-of-way, obtaining right-of-way by the city of Raleigh. Here's a close-up, and again, Keegan highlighted the utility easement, the Duke utility easement, which sort of ends right at the front porches of these 2 buildings. Part of the issue here is obviously that there is not, unlike some of the infill standards in the UDO, which do provide essentially exemptions for these sort of easements, there is no such exemption under the NCOD. Again, we don't think that this is doing any violence to the NCOD. In fact, we think this is actually consistent with the intent of the NCOD. And with that, I will open myself up for questions. I think that's all for our presentation.
Okay, thank you, Mr. Coleman. Questions from the board? Anyone? No? Okay, then let's move to the public. Invite anyone who wishes to come forward to speak to this case. Seeing no one, can move to our closing. We've heard from the board that there are no questions. The applicant's summed up. Mr. McDonald has nothing further to add, I trust. So let's close the hearing and move to our deliberations and motion. This is on specifically 1208 and a half, first case.
Make a motion to approve.
Motion to approve. Mr. Kuntz, is there a second?
Second.
Mr. Butler is a second. Thank you. Any further discussion? All those in favor, aye. Aye. Any opposed, no. Okay, thank you. Moving forward on that one. On the 1208 case, do we need to have the full presentation?
I don't think you opened the evidentiary hearing for that one, so you can have, you need to call Mr. Coleman back up again. It's up to him what he wants to put on for that one.
Okay, the case is BOA 0029-2021, 1208 Garner Road. Mr. McDonald, if you have a presentation, we'll hear it. You simply can go, you've heard it, if you wish, unless there's something new to add.
Yeah, I really have nothing else to add except just to note that the degree of the variance is slightly higher, just related to the condition of the property and where it sits relevant to the right-of-way line and the sampling that was done. But other than that, the facts of the case are largely the same.
Excellent. Thank you so much. Mr. Coleman, welcome back.
Thank you. Toby Coleman, 150 Fayetteville Street. I have nothing further to add. Would ask that everything in the packet be entered into evidence. Again, the same hardship exists here as in the prior case, and we are available for questions.
Thank you. One clarification. I did not check with you. Was there a material to present last time? I didn't ask you if you wanted to submit anything for the record.
We would ask that the PowerPoint that's currently up, as well as the board materials, be submitted in both cases, if that's acceptable.
Thank you. Just covering our bases here, being sure we're getting it done. Okay, thank you. Questions for Mr. Coleman about this case? Pretty much the same as the one we just heard. If not, I apologize. The public has the opportunity to speak to this case as well. No one on this one, so we'll close the hearing officially and move to a motion on 1208 Garner Road.
Make a motion to approve that as well.
Motion to approve. Is there a second?
Second.
Mr. Butler, we have a second. Any further discussion? All in favor? Aye. Aye. Any opposed? We have no opposition. Thank you. Okay, thank you, Mr. Coleman. Now, let's move to our item E, BOA 0. Okay, it's been requested we take, given the time, a short break. We're going to take a 5-minute adjournment, if we may, and then we'll come back together and take on our next item. It's a good idea.
Catfish hunters.
Okay, we'll bring the meeting back to order. Cannot gavel the meeting back to order. It has been brought to my attention to remind everyone to please be conscious of the microphone. This is being broadcast and recorded for future broadcast, and the microphone makes all the difference in the non-visiting public's ability to actually follow these cases. So, okay, now we can move to item E. And this is BOA 0030-2021. This is 10224 Bailiwick Road, and this is a variance. Mr. Hodge, welcome.
Thank you.
I need to give you the oath, please. Do you swear or affirm that the testimony you'll provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Proceed.
So this is a request for a variance from the size and contiguity standards of the forestation areas set forth in section 9.1.9. Specifically subsection 1 of the Unified Development Ordinance, to allow 4 of the required forestation areas to be smaller than the required 1/5, or in this case 2.966 acres in size, in order to construct an approximately 27,294 square foot civic building, tennis courts, and associated parking lot on the site in conjunction with a school. The property is 37.07 acres, Zone Residential 1, Falls Watershed Protection Overlay District, and Special Highway Overlay District 1. And as you mentioned, it's located at 10224 Bailiwick Road and is owned by Trinity Academy. This is an aerial showing the location of the facility. And this image shows the forestation areas in red, I believe, where there are 4 of the areas that are dropping below the requisite 1/5 of the total acreage required. As you may or may not be able to tell, Area 1, however, is oversized. It's 10.78 acres. And then there are 4 areas that drop below the 2.966 acres. The site already has some development, and there are some easements and other restrictions existing on the property that the applicant will go into more detail over, but regarding why cobbling an area together on an existing site in excess of that minimum acreage requirement would be challenging. Staff does recognize the situation at hand and does not oppose the recreation and cultural resources. If you have any additional questions about the forestation regulations, and happy to answer any questions you may have.
Questions from the board? I have one, and it may be a question for the applicant, but I'll start with you. Do you know what the total reduction in the 2.966 acres will be if this is approved?
Well, the 2.966 acres is the minimum size of any one area they're in. So they're meeting their overall site square footage requirement for forestation. It's just a requirement that they have to be split into no more than, to areas no less than 1/5 of the acreage at hand, which again is 2.966 is equivalent to what the minimum area of forestation is supposed to be.
Okay.
Each individual area individually.
Okay. But the overall area of forestation will be reduced. Do you know what that?
They're not reducing the overall requirement.
Well,
it's just some of the areas drop below the 1/5 minimum, but collectively they meet and or exceed their overall obligations.
Thank you for that. Other questions? Then let's invite the applicant forward.
Good afternoon. I'm happy to see y'all in person myself. I'm Isabel Maddox, P.O. Box 946, Raleigh, 27602. I'm here today with Matthew Brazil, the assistant headmaster, head of school for Trinity Academy, who I'm representing today. Trinity Academy is a K-12 private school with approximately 470 students, founded in the 1990s, and it moved to the Bailiwick Road site in 2005. And is my presentation Okay. Okay. So here's the aerial which Eric showed. I think this gives you a little bit better view. This is the existing campus. It was approved before the UDO, but under current UDO regulations, a school is permitted in R1 by right if it meets certain requirements. One of those requirements is that it maintains at least 500 square feet of land area per student. That would require 5.4 acres for Trinity's enrollment. In this case, Trinity has 37.07 acres, and that means they have over 3,400 square feet per student. There's some additional requirements for the secondary watershed. And if we go to Exhibit 2, this outlines really the crux of what's before you today. So tree areas have to be 40% of the total land area, and that can be either tree preservation or newly planted tree areas. And so with 37.07 acres, our total requirement is 14.83 acres, and that we will maintain. But then the sub requirement is that is to be divided by 5 to get your minimum of any non-contiguous area, and that is 2.966, and that's where we have the problem. So if we go to, so our contiguity, the problem with the contiguity is interrupted by sewer lines, some existing, some future, and also existing improvements, drives, etc. And so to just go through the variance standards, one, unnecessary hardship would result with a strict application of the ordinance. And in fact, it would not really allow a school expansion because with the expansion comes, we need to maintain the 2 access points and also extend a sewer line to the property to the north. So we wouldn't be able to do that and also have 5 areas of that minimum size. To go to our next exhibit, this is our site plan. And so we are basically proposing improvements in these 2 areas in the boxes. On the top right, that's the tennis courts. And then at the bottom left, you have a new school building, upper school building, and associated parking. Those are the 2 things we're adding. And that's adding about an extra acre of impervious. We'll still be around 6 acres of impervious total on the 37-acre site. So the hardship here results from conditions that are peculiar to the property, and we believe that is in fact the case. If we go, and unfortunately this is not super easy to see, but the pink shaded area is the area where we're preserving trees. So the yellow is we're planting trees, and the pink we're preserving trees. So you can see the vast majority of this 14.83 acres of forestation area is preserved trees, which is much better than planting, much better for the environment. But you can see that we have some interruptions in the contiguity. The extension, I didn't hit that very well, of the sewer line going to the north, which is a requirement that the city imposes when you're doing any kind of sewer work. They want you to extend your lines to adjacent property owners. So that one breaks our contiguity. Then we have over here, we have a access point. And it's not even actually an active access point right now, but there is an easement there, and that could be a future access point. That's number 2. And then the third place where our contiguity is broken is down here, which is our main access point onto Bailiwick Road. And but for those 3 breaks of the contiguity, we'd have one 14.83 acre forestation area. So next variance requirement is the hardship did not result from actions taken by the applicant or the property owner. And that is in fact the case. We have those 2 access points that are already in existence, and the extended sewer line is a requirement of the city. The final requirement of the variance ordinance is that the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved. And we think it is consistent here. The intent of the tree conservation and forestation regulations is to maintain tree cover, natural resource buffers, and to lessen impact of development. It states that the most significant trees, basal areas, and healthy trees in the best locations shall be considered when granting any kind of alternate. And here, that's what we're asking you for, is an alternate to allow us to drop below those minimum sizes for the forestation areas. And we do think what we're doing is preserving the best trees, because we are we're maintaining tree preservation in these large areas. We have, the one area that is contiguous is 10.78 acres, and that's really far better than a 2.96 acre parcel which was all planted anew. So we think the substantial amount of tree preservation that we're doing outweighs the fact that we are that our smallest forestation areas drops below the minimum. And also in terms of substantial justice being done, we feel like we are adding a stormwater facility that's not in existence today. Let me clear that. That's right there. That'll improve the stormwater conditions in the area. And as we've talked about, we are extending that sewer line there. And most importantly to my client, we're allowing the expansion of an established private school which is growing and needs room to increase its, right now they have a collection of trailers, and this is a new building for their upper school that will allow them to eliminate at least some of the trailers, and it will allow them to serve their students better. So with that, I'm free for any questions, as is Mr. Brazil, the assistant head of school.
Thank you. Questions? Could you just point out, you've referenced the 10 plus acres of contiguous forestation. Could you sort of show me where that is?
Yeah, that is, I'm going to try to draw, can I draw on this? Big circle. And it actually may, now that I look at this, I think it actually comes all the way down here. Okay. That's all contiguous.
Okay, I was trying to do the math. I wasn't getting 10. That's okay.
Yeah, I think that's
okay.
This one goes all the way, contiguous all the way down there. So it's really just, you've got these areas, like you got a really small one right here, which is cut off by sewer lines and the access drive. This one up here is 1.46. The small one is 0.17. And unfortunately, let's see if we can, I don't know if I can. No, I was thinking I could. Nope. I can't seem to get the bottom of that picture to show, but so there are some smaller ones down on the south side of the site.
That's fine. Thank you. Any other questions? Okay, then let's move to the public. Is there anyone here who wishes to speak to this case? Okay, seeing no one.
Okay, well,
Mr. Hodge, while you're there, do you have anything you wish to add, having heard the presentation?
I do not.
Okay. Ms. Maddox, I trust that's it for you?
Yep.
Board members, last chance. Okay, let's close the hearing and move to the board deliberation and motion.
Make a motion to approve.
Thank you, Mr. Butler. We have a motion to approve. Is there a second?
Second.
Mr. Kuntz with a second. Any further discussion? All those in favor, aye. 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 Any opposed, no. Okay, thank you. Okay. Thank you. Let's move along to item F. This is BOA 0032-2021, 3132 Canoe Brook Parkway, and this is a variance. Mr. Hodge.
I just wanted to note that when I read the request, there is a slight revision in the materials that are in board docs. The applicant had a little difficulty kind of bookmarking specifically the request at hand, and to be honest, staff has some challenges when it comes to the specific amount of relief, given the fact that this property or this neighborhood had a previous variance under an old city council granted variance that has since expired. So some of the math in the request had been based on that old variance language, and so we try to do it more generically and more broadly in the original request, but there have been a few nuanced changes, and I'll go through and read you the current request from the applicant. Whereas Pablo Reeder and Michelle Sims, property owners, request a variance to UDO section 9.2.2 in order to permit expansion of impervious surface on a previously developed single-family lot. The total improvements would bring the impervious area onto the lot up to 5,061 square feet on a 0.3 acre lot zoned planned development and located at 3132 Canoe Brook Parkway. As a condition to the requested variance, the property owner has acquired 365 feet of impervious surface allocation from another property in the neighborhood, which is located at 1717 Happiness Hill Lane, through a reallocation agreement. Additionally, the property owner is proposing a condition to install an additional rain barrel for a total of 3 rain barrels on the property. The 2 existing rain barrels were a condition of that previously granted council variance that I had alluded to at the beginning.
Hey, Eric, I hate to stop you real quick, but it's my understanding as well that the applicant has been made aware of this, the numbers in the legal advertisement being what Eric just stated as opposed to what it says, and still wishes to proceed. So I would just make sure when the applicant comes up that you can confirm that with them as well. Sorry to interrupt.
Okay. So this, I believe, is all predicated on the sale of a property. I think there had been some awareness made through survey data that perhaps the impervious surface that has existed on this lot for a number of years somehow may have exceeded the original allocations associated with that variance and the mandates for the neighborhood at the time that the council granted that variance. So I don't believe there's any additional work or impervious surface that's proposed in conjunction with this variance request. This is the survey, showing the existing. I believe the neighborhood homeowners association had a requirement for a pedestrian access from the front door of the house out to the street that may have been added or retrofitted post original permitting, and that I believe in concert with some additional driveway widening years ago is what has pushed the subject property over the amount that was allocated for this lot originally. I believe with the allocation agreement that they have secured, this variance would push them somewhere between 200 and 250 square feet over the amount that they were originally granted. So I'll let the applicant verify that, but I think that's the number that's in question. And by my math, I think it was 205 square feet of additional, once you factor in that reallocation agreement onto the table. That's the situation in a nutshell. We do have Ben Brown here with Stormwater staff if you'd like additional details related to this request.
Okay, great, thank you. Any questions for Mr. Hodge?
Yeah, just wanted, so is this already developed? Is this impervious surface? Are they asking for relief for what's already there?
It's for what's already there. They're not proposing to add anything. In fact, the property's under contract, but I think the purchaser had concerns about this existing nonconformity as it related to an overage and impervious allocation. So they have worked with a neighboring property, a nearby property owner, to secure some additional unused impervious from that lot within the neighborhood, but they still fall shy of the amount, somewhere in that 200 to 250 square foot amount.
Okay, great, thank you. Other questions?
Mr. Hodge, when did that first variance expire you spoke of?
Well, it was granted, I think, in early 2000s, and so it's been expired for a number of years. In fact, this board saw another lot in this neighborhood just maybe 2 or 3 months ago. It was on Grand Journey, and it was an undeveloped lot. So they too, that additional amount of impervious that the council had approved at the beginning when those lots were not built upon, it was sort of a blanket variance to all unbuilt lots at the time. And so this lot, I believe, was built under that variance as well. The lot you saw earlier this year, however, had not been built upon at all. So they were sort of starting from scratch. And we acknowledge that there had been a council variance, but again, it has long since sunset. So it's sort of a factor to understand what everybody else's playing rules were at the time they developed. So that's why, again, the crafting of the language was a little challenging in how to really kind of recognize what the situation is, considering there was that council variance.
Thank you for that explanation. Thank you, Chairman Swink.
Sure. Anything else? Okay, we'll invite the applicant forward.
Good afternoon, Chairman Swink, members of the board. My name is Worth Mills, address 4509 Creedmoor Road, Suite 302, Raleigh, NC 27612. Behind me are the property owners, Pablo Reeder and Michelle Sims. I'd like to go ahead and have them sworn in case the board has any questions for either of them.
Okay, that'd be great. Okay, in turn, if you would state your name and address for the record, please.
Yeah, Pablo Ryder in 6908 Northridge Drive.
Do you swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And your name and address for the record.
Hi, Michelle Sims, 6908 Northridge Drive, Raleigh.
Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And for the record, Mr. Mills, can you confirm the numbers Mr. Hodge introduced are the correct numbers for us to be using today?
Yeah, so the total impervious on the site today is 5,061 square feet. The reallocation of pervious surface from the neighboring property owner is 356 square feet. And so when you consider the 4,500 square foot limit originally with the 356 square feet of pervious from their neighbor, the delta is 205 square feet. And I've got copies of the pervious surface agreement and that plat, which was recorded in late June for Mr. Puccini, that I will pass around.
Okay, thank you. And by introducing these, you're asking us to make this part of the official record.
Yes, sir. Thank you.
Yes, sir.
Okay, so as Mr. Hodge alluded to, this is a variance to legalize existing improvements to 3132 Canoe Brook Parkway, which results in 5,061 square feet of impervious surface on the property. And as a condition, or as conditions to the requested variance, the property owners have already entered into an agreement with the owner at 1717 Happiness Hill Lane for an additional 356 square feet of pervious surface that lot did not need. And also has offered to install an additional rain barrel to their lot, which would bring their total to 3. So this is an aerial of the property today. Note that the home is approximately, it's in similar size to others around it in the neighborhood. Grass in the front yard, grass in the back, although it's a different color than the neighbors at that time. And as Mr. Hodge alluded to, this property is within that Bedford Falls PD and was granted that variance for nitrogen reductions, but as a condition of that variance, impervious surface was restricted to 4,500 square feet or less, and the use of those LID measures, which are on the property today. And as Mr. Hodge alluded to, this property here is 10822 Grand Journey Avenue. That was the property which was before you in April. New build for 6,000 square feet. So we are asking for less than that original or that previous variance request back in April. So this plat here shows the impervious surface of the home when it was constructed in 2014. They were at 4,445 square feet of pervious surface, so 55 feet under the allowable limit. Note that there was no walkway going from the public sidewalk to the front entrance. Note that this was a driveway that could fit 2 cars, but the important thing that I would like to point out is this kind of Carolina style entrance into the parking area. And by that I mean where you have typically like a row of sod or some other pervious surface in between 2 rows of concrete for the car to drive in and out. Shortly after receiving their certificate of occupancy from the city of Raleigh, the Bedford Falls Homeowners Association came to do their final inspection of the property and informed Mr. Ryder and Mrs. Sims that their home was non-compliant with the community's architectural guidelines, namely that they did not have a walkway going from the public sidewalk to their home. Another issue that the property owners faced was with the Carolina-style driveway. Based on their reports, the sod in the middle was consistently getting washed away, was muddy, was never very suitable for that driveway. And so what resulted was you've got cars trying to pull out and turn into and off of that driveway, basically, throwing mud into Canoe Brook Parkway, onto their driveway and into their yard. And so when Bedford HOA told them, please install a walkway to your to the front porch, they went ahead and widened the driveway to mitigate those kind of muddy issues and the inability to effectively turn in and out of said driveway. And so the resulting impervious surface on the property, and I think I'm having the same problem that Miss Maddox had, where I don't know how to make that menu bar drop down, but the resulting impervious surface is 5,061. So you can see here that they widened the driveway to allow for easier access and to get rid of that mud that was being thrown about Canoe Brook Parkway in their front yard. There you go. Look at that. It's like, you leave for 15 months, you forget how to work the technology. But I'll also note that the amount of cars that you can park on the driveway did not change. It was a 2-car driveway or 2-car park driveway before, and it remains that today. Just the width of the entrance and exit has gotten wider, and now you can see a gravel sidewalk here as well, leading to the front entrance. So this is a photo of the driveway as it exists today. You can see it's a fairly typical driveway entrance. It is not unlike many of the other driveways along Canoe Brook Parkway or within Bedford Falls subdivision. And there you can see the gravel walkway leading from the sidewalk to the front porch of the home. And so to go through the variance standards, we believe that unnecessary hardship would result from strict application of this ordinance, which would bring this home out of compliance with its HOA architectural guidelines. Additionally, the original driveway, which was that Carolina style, was very difficult to maintain. It created turning issues for the homeowners, and so we think that by widening that and making that impervious surface, we have made access into and out of the property much safer and much easier. The same goes for the gravel walkway, not having to worry about mud or ice or other elements if you're walking from the sidewalk to the front door. The hardship results from the lot size. Again, we don't have any, really, we had 55 square feet of impervious surface to work with. And again, we think that if we were to go back to a Carolina style driveway, we're going to have the same access issues that persisted prior to them paving that area. We think that the hardship also results from a conflict in the Bedford Falls HOA architectural standards with the 2008 City of Raleigh variance. Obviously, there is a disconnect there, and so if you're in compliance with one, you're out of compliance with the other. And so that is one of the reasons that we are here today, to resolve those conflicts. And as I mentioned, the property owners have contracted with the owner at 1717 Happiness Hill Lane to preserve 356 square feet of pervious surface that that owner did not need to meet her requirements, but that we can now say will preserve. Additionally, the owner is willing to install an additional rain barrel for stormwater collection. And so we believe that through those actions, the property owners are doing the best that they can to meet the spirit, purpose, and intent of the stormwater regulations, which is to mitigate stormwater runoff and preserve the watershed. That's all that we have as far as a presentation, and I or the property owners would be happy to answer your questions. Thank you.
Okay, thank you. Board members, any questions?
Did he submit his packet in evidence as well?
He did.
Okay, good.
Thank you. Anyone? Okay, then thank you. Let's move to the opportunity for the public to come forward if there's anyone here who wishes to speak to this case. Seeing no one, then we will close the evidentiary hearing and move to the board deliberations and opportunity to entertain a motion. Thank you, Mr. Coons. We have a motion to approve. May I have a second?
I was just asked real quickly before you second, is that with the conditions they are proposing or just approving without the conditions?
I was assuming with the conditions.
Okay, I just want to make sure that we're on the same page what the conditions say as well. I've written them down, if you want me to read them into the record.
Would you please?
Okay. This is as I understand them, and Mr. Worth might need to confirm that this is correct. One of the conditions is that the approval by the City of Raleigh and the recording of a plat documenting the allegation of additional, sorry, I can't read my own handwriting, additional 350 or 6 square feet of impervious surface to the property owner from the neighboring property, as described in the applicant's exhibit entitled Pervious Surface Agreement. The second one is that the property owner will install 3 or maintain 3 rain barrels at the property to mitigate stormwater runoff. Is that correct? Okay.
You said 356?
Yeah, and that was part of my question too. I think the pervious surface agreement says 350 on it.
That's what this letter said.
Right, so maybe if you want to come real quick and just clarify what the correct number.
Yeah, so that that pervious surface agreement was signed in March, and I believe that after a proper survey was done, they were able to find an additional 6 feet. So what's been recorded and what's been reviewed by the city of Raleigh is 356.
Perfect.
I'm going to note that we did not officially reopen the hearing, but I think we will accept that information with the assumption we would have and move along. But thanks for the clarification. Good catch. Okay, so
those are and I'll send you that in writing as well.
So, Mr. Kuntz, you have a motion including the 2 conditions. Is
By
that
all
correct?
means, we're exactly that.
I'll second that.
Great. Okay, we have a motion and a second to approve with the 2 conditions as offered. Any further discussion? All in favor say aye. Aye. Any opposed, no. Then that case is approved. Thank you very much. And we'll move to our next item on today's agenda, BOA 0033-2021, 104 Lord Ashley Road. And this is also a variance.
Property owners Stephen and Phyllis Barber are requesting a 16-foot variance to the front yard setback requirement set forth in UDO section 5.4.3.f, .6, .a, Romanet 3, resulting in a new front yard setback of 60 feet to allow for an expansion of an existing single-family residence on a .82 acre parcel zoned residential 4 and neighborhood conservation overlay district, specifically the King Charles neighborhood. And the property is located at 104 Lord Ashley Road. So this is an aerial showing the existing home. The survey here, the areas in gray are essentially where they're looking to add additional square footage. This portion at the back is a ground floor addition at the rear of the property, so no issues there in terms of setback relief or variance is needed. However, this portion is a 2-story addition on top of the existing home. And because, as you can see, the yellow dash line runs through the middle of the house currently in terms of setbacks, that neighborhood conservation overlay district was added many years after the home had been constructed. So it's an existing nonconformity. The applicants would be able to expand as proposed, violating the front yard setback through a special use permit, rather a variance, had the increase in square footage been below the 25% threshold based on the existing square footage of the house. I believe the additional square footage comes in somewhere around 730, 750 square feet, somewhere in there. So it's not a very big addition, and they're essentially just popping the top of the center portion of the house and adding an addition up within the attic space. I think the applicant has some images here showing you a little bit better the existing home and then the proposed addition. So it's that second story piece that is encroaching within the neighborhood conservation overlay district setback. So in terms of the footprint of the house, it is getting no more severe in terms of violation, but the city does essentially have a policy that any additional square footage must conform, even if it's on the second floor. So that concludes my presentation, unless you have any questions of me at this time.
Thank you, Mr. Hodge. Questions? Okay, seeing none, let's move to the applicant's presentation.
that or just hit the enter to advance. Perfect, thank you. Backspace if you need to go back. Great.
Good afternoon. My name is Jim Eatman. Address is 4130 Park Lake Avenue, Suite 100, Raleigh, North Carolina, 27612. I'm here today on behalf of Mr. Stephen Barber and Mrs. Phyllis Barber, the property owners at 104 Lord Ashley Road. Both of them are here today and happy to answer any questions as needed. Also with us here today is Mrs. Tika Hicks. She prepared the plans for the proposed improvements and again is available to answer any questions that the board might have. Before I get any further, I would like to ask that the presentation be submitted into the record at this time.
Okay, thank you. Mr. Hodge did a great job describing the request, so I'll just quickly reiterate a couple of things. Again, we're requesting a 16-foot setback to the 76-foot front yard setback that's applicable under the UDO, specifically the King Charles NCOD. That would result in a new front setback of 60 feet, and we're asking this, the purpose of this request is expansion of the home and approximately 730 square feet being added. This is the same plot plan you saw earlier. Just quickly note a few things. Again, the NCOD setback runs right through the middle of the house. This came into effect years after the house was built, and the encroachment was created as soon as this was applied. You can see the area of the proposed improvements. The proposed second story is on top of the existing footprint of the building, as noted here on the plot plan. And as Eric mentioned, we're adding a small expansion on the back of the house on the first floor only, and this part of the expansion does not violate any setbacks or any other provisions of the UDO. You've seen these as well. I just wanted to point out this picture from the IMAPs on the left. There's still a large front yard here, even with the existing encroachment. Obviously, we're not increasing the encroachment, but just from a practical perspective, it's not like the house is on top of the road and we're going to be towering over the road there. On the right is a screenshot from Google Earth. This shows that there are a lot of trees and a natural buffer on the lot. Those aren't being removed. And basically from the street, this house will look much like it always has, which we would contend is consistent with the goals of the NCOD. Here again is the street view of the house. Again, the setback runs right through the middle of it. This just gives you an idea of the current configuration, and I'll go ahead and move on to the proposed improvements. The front elevation, the front plane remains in the exact same location before and after the proposed improvements. Won't be any closer to the street than the house has always been. You can see the second story is only over a portion of the house. This is a relatively minor addition. It's not covering the entire width of the house there. It's a moderate increase in height. The increase in height is permitted under the UDO. And you can see as well on this front elevation that they're making some other improvements, putting in new windows, repairing screens, replacing existing steps, sort of some minor improvements to go along with the added second story. Here's the rear elevation drawing. It gives you an idea of that first floor addition coming off the back of the house. This, again, it doesn't violate any setbacks, rear setback. This will give the property owners some more space without having to add that full-on second story or go further into the front setback. Because the setback goes through the middle of the house, they can't really add space on the sides of the house without violating the setback. If they were to do that, you'd be left essentially with two very narrow wings. And even if you did expand on the sides, the front of the house would still be encroaching, and obviously it's impossible for the owners to change that. Here's a side elevation drawing. Again, just to really emphasize the point that front plane, which is on the right side of the picture you're looking at now, is not being extended any further into to the front setback. It also gives you an idea of the
the size and scope of the first floor addition coming out of the back of the house. Moving on to the standards for variance, the first, that an unnecessary hardship would result from strict application of the ordinance. As I believe Mr. Hodge noted, this house was built in the 50s. The Barbers would like this to be their forever home. To do that, they need to update the home, and improvements like these give them more living space. They improve just the utility of the home. Some of the other improvements I mentioned, like the new windows and new steps, increase the value of the home. They increase energy efficiency. The repaired screen and windows, they increase security. So these really are necessary improvements for the Barbers to stay here long term. And another hardship, as I previously noted, would be that there is really no practical alternative for expansion here where they could avoid a variance. Mr. Hodge referenced the special use permit option. That would limit what's already a very small addition. It essentially would not give them the space they need with the special use option. In terms of alternatives, again, they can't go off the front, they can't go off the sides, they can only go so far in the back based off the rear setback and the existing infrastructure. So going partially back and partially up without furthering the existing encroachment makes the most sense here. The hardship results from conditions peculiar to the property, certainly the case here. You can see this is somewhat of a unique shaped lot. The lot is wider than it is long. Pretty much every other lot in the neighborhood is longer than it is wide. If the Barbers had a lot like that, they could more easily go backwards with the expansion. I'd also note the orientation of the home within the lot. The home was built in the middle of the lot long before this setback was ever applied, and that's peculiar to the property. The next standard, that the hardship did not result from actions taken by the property owner. Again, that's clearly the case here. The hardship was created by the application of the NCOD and the setback. The Barbers didn't build the home. They've done nothing to increase the encroachment, and they're not doing anything to increase the encroachment with these proposed improvements. The final standard for a granting of a variance is consistent with the spirit, purpose, and intent of the ordinance. Again, the intent of the UDO presumably was not to make everything non-conforming as soon as it was applied, which is exactly what happened here. We would contend that the purpose of the UDO and the NCOD is to prevent new violations or furtherance of existing violations, neither of which are happening here. These are relatively minor improvements. They're consistent with the current appearance of the home and the general appearance of the neighborhood, which again we would say is consistent with the spirit, purpose, and intent of the ordinance. And on top of all that, this doesn't have any adverse effect on the neighbors, the public, health, environment, safety, and welfare, is evidenced in part by the fact that there's no opposition here today. So with that, I will quickly conclude. Again, this is a 16-foot variance to the front lot line setback. It's a 76-foot setback, that will leave us with a new setback of 60 feet. The existing encroachment, which is long-standing, would not be increased by a result of these improvements. And the encroachment originally arose solely as a result of implementation of the NCOD. So with that, I will conclude my presentation, and if you have any questions for me or the TICA or the Barbers, we are happy to answer.
Thank you, Mr. Eatman. Board members, any questions? Seeing none. Okay, we'll give the opportunity for the public to come forward and speak to this case if there's anyone who wishes to do so. And I don't see anyone. So we can move right to our closing unless, Mr. Hodge, you have anything else you wanted to add?
I do not.
Okay, great, thank you very much. Okay, then we will close the hearing and move to our motion opportunity for deliberation of the conditions, if there are any.
Make a motion to approve.
Thank you. We have a motion to approve. May I have a second?
Second.
Motion to approve from second Mr. Sutton. Any further discussion? All in favor say aye. Aye. Any opposed, no. Or hearing none. Okay, thank you very much. That concludes our agenda for today. Moving on to our other business, which is starting with the approval of the minutes from our draft minutes of June 14th, 2021. Any additions, corrections, or a motion to approve? I will move that we approve the minutes, the draft minutes from June 14th, 2021. May I have a second?
A second.
Name is Russo. I have a second. Any discussion? All in favor, aye. Aye. Any opposed? Okay, thank you. Ms. Hill, anything from you today?
No, nothing.
Great, thank you. It's great to be back. Election of officers. This is a time of year, first meeting of the July of the new fiscal year. We elect officers, chair, vice chair, and secretary. So we'll start with the chair's position. Is there any nominations?
I nominate Mr. Swink to serve as chair.
We have a nomination from Mr. Butler for Mr. Swink.
Second.
We have a second on that. Anyone else to be nominated? Then let's put it to a vote. All in favor say aye.
Aye.
Any opposed? Okay, thank you very much. As to our chair-elect, currently Mr. Kuntz, and I would like to renominate Mr. Kuntz as chair-elect. Do I have any other nominations? Hearing none, we move to a vote. All in favor say aye. Aye. Any opposed? Great. And our secretary, Mr. Mile, is not here. I understand, Mr. Butler.
I nominate Mr. Ma for secretary.
Thank you, Mr. Butler.
For nominees.
Excellent. He has indicated in past his willingness to serve. So we have a nomination for secretary. Any others? Then let's move to a vote. All in favor, aye. Aye. Any opposed? Okay, thank you. Let me say now, thank you for the vote to move forward. I think it's great with this transition back to regular meetings. I'm not expecting to do this job forever, and it's an opportunity for everyone else to step up and have opportunities. I think we're all volunteers to the city, and we ought to all have opportunities to sit in this seat. So please express that interest at any time, and we'll turn things along. We don't need to keep doing this as we're doing it.
Thank you for your leadership during the pandemic. So
it's
trying time for all of us, and
you
and John did a great job. So we appreciate that.
Well, it was great staff. Ms. Hill specifically, she gave me, I could not have had an easier script to work from. She made me look so good, and it was really her work. So, but it's great that you're all here. We're all back together. We're healthy. It's a blessing. Let's take advantage of that and continue to stay healthy. And we'll, unless there's something else anyone needs to offer, Mr. Hodge, something?
I just wanted to introduce my new colleague, Mr. Justin Booker. He'll be presenting some of the cases, I believe, at your next meeting.
Excellent.
He's coming to us from the town of Cary.
Excellent. Well, I think there's a meeting in October on that.